Thank you, Count Corla. This is a rather complex and long-running case the consequences for which reach into so many areas of public policy. It will have complications. It will have consequences for Brexit. It will have consequences for FDI, for foreign trade. The reality is, quite simply, off the back of this judgment, the EU-US privacy shield has been declared invalid, and as such, there is no way that is safe and legal to transfer data from a European Union citizen to the United States. So any company that is doing such data transfers is doing so at significant risk. This case was started in June 2013, 7 years ago. So hopefully now, finally, that we have this judgment, we can see some real action in terms of protecting the fundamental rights of European citizens in terms of their own data and privacy. The EU-US shield its collapse and its demise was inevitable. It was widely predicted. It was a replacement for the previous safe harbour arrangement with little changes to the safe harbour arrangement, which was declared invalid. So this was inevitably going to happen. So it would be really positive if we could see some action from the data protection controller to prevent what are, according to the courts of justice in the European Union, unsafe, illegal transfers of data. And in fact, the German data protection controller has already been warning people that they should stop these data transfers because of the failure, the demise of the EU-US privacy shield, and because of the insufficient safeties built into the standard contractual clauses which companies are now going to have to rely on. So, the plaintiff in the case, Max Schrems, had published an open letter to the Data Protection Commissioner here, asking her when she is going to take action. So that's one serious thing that we need to know. When will the action happen? But the important follow-up question is can the Data Protection Commissioner actually act? Have we given her the resources to act properly? While her budget has increased, it was only a third of what she asked for. It has failed to keep pace with the complexity and the volume of complaints that her office are receiving. We've seen her struggle to deal with this case. There are serious complaints in relation to real-time bidding, which is a very scary practice in terms of data privacy, that have just seemed to stalled and going nowhere. And indeed, other data protection controllers around Europe, other data protection authorities around Europe have called us out as the roadblock for meaningful enforcement of the GDPR. So, we need to say, when is the action going to happen? And are we actually doing enough to give the Data Protection Commissioner what she needs to act? And I've said in this chamber several times before, we haven't. And the reality is, as I say, after this judgment, not only is her workload going to become more complex, it's going to massively increase. She already doesn't have enough resources, so we need to be doing more. And this has huge, huge consequences for so many areas.
Count. It's very nice to be back on this side of the House. I think first time in almost 10 years for me, and I'm glad to be responding on behalf of the Minister for Justice tonight in relation to this. It's a very important case. You've mentioned the implications for Ireland's data protection regime of the recent European Court judgment on the EU-US Privacy Shield. And I welcome the opportunity, Count Corla, to update the House on the matter. The Government respects the views and findings of the Court of Justice and is fully supportive of the need to protect European citizens' data. This is an issue that affects us all and should be subject to the highest protections. The Minister acknowledges that the Court's decision to strike down the EU-US Privacy Shield is a matter of serious concern for Irish and European businesses that transfer data to the US. But the Minister welcomes the Court's findings upholding the use of standard contractual clauses to facilitate the transfer of data between the EU and countries outside it. The Minister notes that in these matters it is important that we respect the independence of the courts and the Data Protection Commission. The Data Protection Commission is an independent national authority responsible for upholding the fundamental right of individuals in the EU to have their personal data protected. The DPC is the Irish supervisory authority for the GDPR and also has functions and powers related to other important regulatory frameworks, including the Irish e-privacy regulations and the EU directive known as the Law Enforcement Directive. Matters in relation to data protection are governed by a number of legislative frameworks, including GDPR, the Data Protection Acts, the Law Enforcement Directive and the 2011 e-privacy regulations. But the DPC is entirely independent of government, as is required by the GDPR. In light of the Court of Justice ruling, together with our EU partners, we will need to examine the impact that the Court's decision will have on the continued use of standard contractual clauses. While the original reference to the Court of Justice did originate from our High Court, this is not solely an Irish matter, as the Deputy has alluded to, and it is not one, though, that we can unilaterally fix. The Court of Justice ruling strikes down the European Commission's adequacy decision on the EU-US Privacy Shield. We will need to review the Court's judgment and will work with the European Commission and our European partners to contribute to a solution.
The reality is that while the standard contractual clauses were not struck down in the judgment, the standard contractual clauses are only valid where the data protection controls in place in the third-party country are considered to meet that adequacy standard. And the reality is that American data protection standards do not meet that adequacy standard. We've seen that with the Safe Harbour. We've now seen that with the EU-US Privacy Shield. There is no way that these standard contractual clauses will hold up to examination. Now, what's going to happen is that our data protection controller will have to individually examine each of these about 5,500 SCCs. And again, that's adding to our workload. But it is deeply predictable that these things will just not stand up because the adequacy is not there. And the same problems that mean that the US data protection controls are inadequate exist in the UK. We very soon will not be able to transfer data from here to the UK, which is going to make Brexit just a little bit more awkward, and it's already bloody damn awkward. I would argue as well that the Data Protection Commissioner is not entirely independent of government. It is us who provide her budget. It is us who ensure that she has adequate staff and resources to do this work. Her work has just become significantly more complicated, and her office were already struggling under a weight of complaints and a complexity of complaints. So, we have a situation here where we need to fund the Data Protection Controller more, and we need to be looking very seriously at the consequences, because these standard contractual clauses, quite simply, will not stand up and are not safe. And in fact, any transfer of data should not be happening until they are certified as adequate, which just will not happen given the record of decisions that we've already seen on this.
Thanks very much. As I've outlined, the Government is fully committed to the highest standards of data protection being in place for the benefit of Irish and EU citizens. The Minister supports the entitlement of people across the EU to exercise their rights to data protection. The independence of our courts and the European Court of Justice must be respected, though, as indeed must the independence of our Data Protection Commission, though I do take on board the point that Deputy Costello has made about the funding position. That doesn't detract, I think, from the independence which we all accept. While the Minister appreciates that the Court of Justice decision to strike down the Privacy Shield is a matter of serious concern for Irish and European businesses that transfer data to the US, the Minister welcomes the Court's findings upholding the standard contractual clauses. The Minister is confident that the issues arising from the judgment can be resolved by working in conjunction with our EU partners. In doing so, the Government will endeavour to arrive at practical solutions. Again, I would like to thank Deputy Costello for raising this important issue and for his comments on the matter, which I think are very helpful to the debate.